Yes, Your Honor.
Yes, Your Honor.
All right. Prosecution, you may proceed when you're ready.
Before I begin, may I request that all remaining time of 5 minutes be reserved for rebuttal?
You may.
May it please the court? Every decision the defendant made led directly to Vanessa Sullivan's death. Ultimately, whether she lived or died was the defendant's decision. As the prosecution in today's case, we have brought charges of murder and driving under the influence against the defendant. We had to prove these charges beyond a reasonable doubt. As most of you may know, driving under the influence, or DUI, simply means that the defendant was operating a motor vehicle under the influence of alcohol. And today we have heard over and over and over the defendant was drinking the night of September 24th. It's not an issue. Drinking for more than 10 hours straight. We've heard that his speech was slurred, that he was stumbling, that he failed 3 field sobriety tests. The defendant even admitted to Miss London Bennett that he was tipsy. He shouldn't have been driving. There is no question the defendant is guilty of a DUI. That leads us to murder. Today, what you will be considering is called extreme reckless murder. My co-counsel, Ms. Shelby Smith, came before you earlier and asked you to keep 3 questions in mind. By answering these questions, we have proven extreme reckless murder. I want to take a look at each of those questions and how we've answered them today. The first question, did the defendant's actions create a reasonably foreseeable risk of harm? Now, specifically what we must consider are the driver, the conditions of the road, and the weather. And as we've heard today from Ms. Bennett, Canyon Road was a dangerous road. There are no guardrails that extended through the turn on Canyon Road. There are trees just feet off the road. There are no street lights, so it's dark. There have been fatalities there in the past, and Mr. Lyons told that to the defendant before September 24th. We also heard that it was pouring down rain. There was a flash flood warning where the accident took place. We heard that the speed limit in that turn is 35 miles per hour. And when we consider the driver, the defendant, speeding, swerving, driving drunk, members of the jury, it wasn't just foreseeable that someone in that car would suffer harm. We could have expected it. As Mr. Lyons told you, it was no surprise the car ran off the road. Which brings us to the second question. Did the defendant disregard the risk? Today we heard that the defendant began disregarding the risk when he sat down at the bar and decided to get drunk. He disregarded the risk when he shoved a cab driver out of his way. He disregarded the cries of Vanessa Sullivan and Taylor Hobson. He disregarded the weather, the conditions of the road. He disregarded every risk that night. And when we think back to his words, he didn't just accept the danger. He saw it as a challenge that he accepted. By answering these 2 questions, we have shown you that the defendant was reckless on the night of September 24th and the early morning of September 25th. The last thing we must consider is whether or not that recklessness created a serious risk of death to Vanessa Sullivan. Today we heard from Officer Foster. Officer Foster is a member of the fatal crash team. He performed an analysis and reconstruction of the accident. And he told you that when the car lost control, the defendant was driving at 66 miles per hour. Even after sliding almost 300 feet, the length of a football field, down Canyon Road, when the car hit that tree, it was still moving at 45 miles per hour. Members of the jury, 66 miles per hour in the pouring down rain, drunk, with trees just a few feet off the road. It's a fatal speed at which to travel. We heard that in the past, speeding caused fatalities on that road. We heard today that speeding caused a fatality on that road. The answer to the question is yes. And unfortunately, the Sullivan family knows the answer all too well. Members of the jury, we have met our burden. Today, everything we aim to prove, we have proven. But in just a moment, the defense is going to come before you. Ms. Jeter is going to try and explain all of that away. She's going to tell you that this was a mistake. It's not murder. The defendant did not mean to kill anyone. It's not like he had a gun. Let me be clear. This is murder. There's no doubt about it. Because in a moment, the judge is going to tell you about the law in Midlands concerning murder. He's going to tell you that if the defendant's actions created a reasonably foreseeable risk of harm, if the defendant disregarded that risk, made the decision to act anyway, it doesn't matter if he meant to harm anyone. He's guilty of murder just the same. The same as if he had a gun and pulled the trigger. Because when we think about it, as the defendant swerved down Canyon Road, just like a hostage at gunpoint, Vanessa Sullivan, she was helpless. She was terrified. And just like a gunman, the defendant had two choices. He could stop the car, slow down. He could lower the gun. And then everybody goes home. Everybody lives. Or he could pull the trigger. The defendant made the decision to ignore Vanessa Sullivan's cries, to step on the gas, to pull the trigger. Did he have a gun that night? No. But the law says it makes no difference because the fact is, we get the same result. The fact is, Vanessa Sullivan never made it home. The fact is, murder is murder is murder. It doesn't matter how you do it. It's not about a gun or a knife. It's about the decision the defendant made. That's why he's guilty. Thank you.
Dawson did make a decision that night. He made a mistake. But a mistake is not murder. Danny Dawson made the decision to drive that night. Why? To help his friends get home on time. And when he did that, he made a mistake. When he got behind the wheel of that car, he made a mistake. There are three main facts in today's case. And there are three questions you should think about when making your decision today. First, was Danny Dawson severely intoxicated at or around the time he left Chucky's? Second, did the conditions and the circumstances on the road that night play a major role in the accident? And third, is the prosecution out for revenge rather than justice? First question. Was Danny Dawson severely intoxicated at or around the time he left Chucky's? Now, you heard from numerous witnesses today You heard from Jordan James, the bartender, that when Danny Dawson left the bar, his hands weren't shaking, he wasn't stumbling, and he was not slurring his words right before he left the bar. You heard from Sam Lyons, the cab driver, who saw Danny Dawson outside of Chucky's right before he got to the car. He told you that Danny was not slurring his words, that he was not stumbling. And both witnesses told you that they didn't think Danny Dawson was intoxicated at the time he left Chuggy's bar. You also heard from the prosecution's witness, London Bennett. She told you that she saw Danny Dawson after the accident and that she didn't think that Danny was drunk either. Now you also heard from the officer Ryan Foster today. Now he told you that he would pull over somebody if they were too intoxicated to drive, if that's what he thought. But did he pull over Vanessa Sullivan's car that night? No, he did not. When his job told him to pull over someone who he didn't think should be driving that night, and he didn't, that tells you he didn't think that they were intoxicated. He thought they were okay to drive. And why? Because Danny Dawson was not severely intoxicated when he left Chuggy's bar. And even the prosecutor's witness, Taylor Hobson, who is known as a person that that does not like drinking and driving, and that always tries to prevent it. She had decided to not stop Danny from driving that night, and she actually got into the car with him. Why? Because Taylor Hobson must have not thought that Danny Dawson was too drunk to drive. It was a mistake that he had a few drinks that night, a mistake that he got behind the wheel of that car, but Danny Dawson was not so severely intoxicated that he could not operate, or he was not so severely intoxicated that this was murder. Second question you must remember. Did the conditions and circumstances on the road that night play a major role in the accident? Now you heard from numerous witnesses that it was raining. You heard from Ryan Foster, it was a torrential downpour. You heard that road, that canyon road, is a death zone. That the guardrail doesn't extend far enough. That the pavement was slick. That there are no lights except for the one at London Bennett's house. It's pitch dark. Raining. And then you heard from our expert witness, Leslie Roman, that the accident is consistent with an object, like a deer, jumping out on the road. That's what happened, ladies and gentlemen. A deer jumped down the road, and with all those conditions, led to the accident that happened on September 25th, 2010. And the third question you must remember. Is the prosecution out for revenge rather than justice? Now, you heard that the district attorney showed up that night on September 25th. She assisted in the investigation that night. She made several comments that she was going to make Danny Dawson's life a living hell, because she still could. And that she needed more evidence for her murder investigation. The prosecution forgot to tell you about the mistake they made when they charged Danny Dawson with murder before investigating the case thoroughly. We admit to our mistake that Danny Dawson should not have been behind the wheel of that car that night. The prosecution won't admit to their mistake. Now, you heard a few questions earlier that the prosecution must prove in order to make their case. They must prove that the defendant's actions create a reasonably foreseeable risk of harm. The fact is, no one could foresee a deer jumping out in a torrential downpour with no lights in a death zone that night at that time. And that leads to their second question. Did the defendant disregard the risk? Did he disregard the risk of that deer? Well, can't really say, can you? And lastly, did the defendant's recklessness create a serious risk of death to Vanessa Song? Members of the jury, the defendant was not reckless. The defendant's mistake created a serious risk. Again, members of the jury, a mistake did occur on September 25th. A tragedy did occur on September 25th. Vanessa Sullivan lost her life and a family lost their child. However, the mistake that Danny Dawson made does not equal murder. Danny Dawson is not guilty of murder. And this is something that the prosecution had to prove to you today, but they were not able to do that. But they did do a very good job today. A good job of playing on emotion. You saw a lot of emotion today. A woman lost her life, a family lost their child. But as the jury, you must look at the facts, and the facts alone today. And the facts are that Danny Dawson is not guilty of murder. Now, the prosecution must prove beyond all reasonable doubt that Danny Dawson is guilty. And that is the highest standard in our legal system. But they have not done that today. They have not presented facts, but emotion. And you must be a just jury and set aside that emotion, as hard as it may be, and look at the facts. And the facts alone. And the fact is, Danny Dawson made a mistake by getting behind the wheel of the car that night. A mistake is not murder. Now, in a few minutes, you're going to have time to go back in that room and deliberate. And Danny Dawson's life and this trial will be in your hands. And when you go back there, I'm confident that you will find the only verdict that makes sense in today's case. That Danny Dawson is not guilty of murder. Find Danny not guilty because a mistake, that one decision he made to get behind the wheel of that car, is not murder. Thank you.
Any inquiries how much time I have remaining?
Say 30 seconds.
You said 45?
45.
May I proceed?
Yeah.
A mistake. A mistake is an accident. When you make a mistake, you do not mean for it to happen. When Danny Dawson got drunk, it was no accident, it was a decision that he made with every order, with every sip. When he got behind the wheel, it was no mistake. He pushed a cab driver out of the way. It was his decision. And when he lost control of the car and ended an innocent life, it was no mistake because he made the decision to drive double the speed limit in terrible weather down a dangerous road. The only mistake we can make here today is letting a murderer walk free. So make no mistake and find the defendant guilty. Thank you.
Say, make no mistake.
All right. One thing that a lot of law school students who are judges and nitpicking judges will hammer people for on closing is talking about facts that didn't come out in the course of the trial. We had a little bit of that on both sides, but maybe I made a mistake, but didn't your expert say that he was traveling 61 miles an hour?
66.
Okay. And didn't your expert say that the speed limit on that road is 35 miles an hour? Well, 66 is not double the speed limit.
Said almost. Almost.
And there are a lot of other little tiny things that, didn't come out. but just be careful of that on both sides. You did good going into your, all these people that said that Danny was okay to drive, but you left out the most important one, I think. Vanessa Sullivan said Danny's fine, right before she got in the car with him. Yeah. Yeah, actually, I think, yeah, on Cross it came out of one of their witnesses. So, that's one. We've got to work on the first half of your close was good, Kim. We've got to work on a way to make a more emotional plea to the jury, and not violate the golden rule, but be like, hey, we've all had a drink or two of driven, and probably shouldn't. We're just lucky that this didn't happen to us, kind of deal. Which, on a side note, it's always, as a police officer, I've always wondered, if Grady and I have the exact same amount to drink, and we both leave the bar to go home, and that is all our intentions are, and I happen to get stopped by Mountain Brook and get arrested for DUI, and get a slap on the wrist and a $600 fine, and he happens to go on his way home and kill somebody, he's charged with murder. It just seems odd to me that there's different penalties for the exact same action. And maybe that's something that you can play up, we'll just have to work on a way to make it a more emotional plea to a sympathetic defendant, for the jury to, have mercy on, basically. There are some content issues